Justice BV Nagrathna's dissenting views on demonetization and free speech were popular topics for editorials in the week gone by. The lone woman in the Supreme Court's bench on the matter, Justice Nagrathna deemed the Union government's decision to demonetize 500 and 1000 rupee notes to have been unlawful. As per Pratap Bhanu Mehta, Justice Nagrathna's dissent on demonetization verdict tries to affix administrative responsibility and does not let officials hide behind the smokescreen of statutory interpretations. What is the smokescreen of statutory interpretations? And what were the two dissenting judgments by Justice Nagrathna? Dissent has become an increasingly rare phenomenon with authoritarian regimes at the helm of affairs. In Rohinton Nariman's book on some of the historic dissenting judgments, he quotes American jurist Felix Frankfurter as saying, and I quote, "Dissent is essential to an effective judiciary in a democratic society. It records prophecy and shapes history." In contention today are two dissenting judgments pronounced by SC Judge BV Nagarathna. The first in the case of Supreme Court terming the demonetization exercise as valid and saying that it satisfied the test of proportionality, and the second where the SC held that a government won't be held responsible for irresponsible statements made by the ministers. Let's concentrate on the first judgment for now. On 16 November 2016, Prime Minister Narendra Modi had made an announcement demonetizing rupees 1000 and 500 currency notes. Now 6 years since the mammoth exercise, the Supreme Court has upheld the decision's validity in a 4-1 majority judgment. The majority verdict said it was not relevant whether the objective of the overnight ban was achieved. However, Justice BV Nagarathna dissented from the majority judgment, saying the scrapping of the whole series of rupees 500 and rupees 1000 currency note had to be done through a legislation and not through a gazetted notification, as Parliament cannot be left aloof in such a matter. The 21,000 word long dissenting opinion of BV Nagarathna makes one question the 4-1 verdict given by the Supreme Court. As P. Chidambaram says, this dissenting opinion will go down as one of the best in India's history. Nagarathna's opinion tries to simplify and understand the meaning of the RBI Act. She said that the decision of demonetization should have been taken by passing a bill, and I quote, "RBI is not just any other statutory authority. It is not like a stream which cannot be greater than the source. The power conferred upon RBI under Section 3(1) of the RBI Act to take over the management of the currency from the central government cannot be taken away. The sole right to issue banknotes in India also cannot be taken away." Further, Justice Nagarathna states that the objective of the government were well thought of in terms of eradicating black money, terrorism, etc. So if that's the case, then the central government should have initiated a proposal for demonetization and not declare it through a gazette, she said. Nagarathna stressed the fact that a decision as big as the demonetization of 84% of the total notes in circulation should have been taken via Parliament. And I quote, "It is necessary that the Parliament, which consists of the representatives of the people of this country, discuss the matter and thereafter approves and supports the implementation of the scheme of demonetization," she said. In her entire dissenting opinion, Justice Nagarathna takes apart the semantics of Section 26(2) of the RBI Act. Section 26(2) of the RBI Act says that the central government can issue a notification in the Gazette of India to demonetize any series of banknotes of any denomination, but only on the recommendation of the central board of the bank. Firstly, the plain meaning of the words "any" series of banknotes of any denomination would not imply all series of banknotes of all denominations. It is clear from her observation how the meaning of the word "any" was interpreted as all to suit the government's decision. Regarding this point, Bhanu Mehta makes an interesting observation. He says the RBI Act was not designed for an unprecedented policy measure of this kind. It was designed for what might be called technical demonetizations, not the whole-scale withdrawal of the currency. Nagarathna further notes that RBI did not apply their mind and only followed suit. Justice Nagarathna says, and I quote, "The use of the words phrases such as desired by the central government had recommended, the withdrawal of the legal tender of existing rupees 500 and rupees 1000 notes, recommendation has been obtained, etc. are self-explanatory. This demonstrates that there was no independent application of mind by the bank. Thus, demonetization exercise was deemed unlawful in the eyes of Supreme Court Judge BV Nagarathna, as the RBI acted at the behest of the central government and did not render an independent opinion to the central government. Although the Supreme Court decision says that it is not relevant if the objectives of the ban were fulfilled or not, we ought to look back at the promises made by the government in 2016. Government said that demonetization will stop terrorism in Kashmir. Well, 6 unarmed people were killed in Rajouri on Tuesday. There are instances of Kashmiri Pandits being targeted even 6 years after demonetization. Another objective was to create a cashless society. Despite the digital payment boom, most Indians still depend on cash for their daily survival. As per RBI's official statistics, the cash with public is almost 71% higher than the level for the fortnight ending 4th November 2016. This essentially defeats the claim of a cashless society. Thirdly, the government promised that the demonetization would bring back black money and would end corruption. Well, India is ranked 8th in the world in black money generation by the Global Financial Integrity Report. Moving on to the second dissenting opinion, the same bench of judges who pronounced the demonetization verdict were listening to another matter. It was about imposing extra restrictions on politicians and ministers regarding their right to free speech. The bench said that a statement made by a minister cannot be attributed vicariously to that of the government under the collective responsibility principle. While Justice Nagarathna agreed with the majority view, she said that in case a minister makes disparaging statements in his official capacity, then such statements should be vicariously attributed to the government. She also expressed concern over the rising cases of hate speeches in the country. The concerns of Justice Nagarathna are justified, as we have number of instances of politicians making hate speeches. The very famous one where Union Minister Anurag Thakur had made provocative slogans just a few days prior to the Delhi riots of 2020. These were the two cases where BV Nagarathna dissented from the majority opinion. In conclusion, I leave the viewers with this quote from Rohinton Nariman's book on Dissent. And I quote, "A dissent in a court of last resort is an appeal to the brooding spirit of the law, to the intelligence of a future day when the later decision may possibly correct the error into which the dissenting judge believes the court to have been betrayed." Thank you.